All right, good morning, everyone. Thank you all for joining us for today's webinar, Navigating the New Normal, Reopening Offices During COVID-19. So this is a topic of significant interest as states begin to relax social distancing restrictions, allowing for an increase in outdoor activities, and of course, a gradual return to work. PROXUS, along with our friends and colleagues at McErlane, are pleased to be able to bring you today's presentation. So a few quick housekeeping items before we jump into the conversation with my two guests today. Today's webinar is being recorded and we will send the recording out at the conclusion. Attendees are encouraged to submit questions through the questions panel in their user interface. Questions submitted in advance of today's webinar will be addressed towards the end of our discussion. And then finally, contact information for all of our presenters will be shared on the following slides. Please do make sure to make use of that information should you need, and we will have it on the screen here twice, once at the beginning and once at the end if you do need to take it down. With that, I'd like to introduce those who will be on the line with us this morning. My name's Matt Rossler. I'm a Business Development Director here with PROXUS. I'll be moderating today's discussion. My background includes over 10 years of human resources management and consulting experience, guiding both for and nonprofit clients in the small to medium-sized market around their HR and HR technology needs. So as part of PROXUS's HR management team, I've assisted clients through HR audits, compensation plan development, HR outsourcing arrangements, and more. And in my current role, I continue to support clients with those same sorts of solutions, as well as implementation of our full service human resources management technology platform. Most recently, I've seen an increase certainly in our increased interest, in our learning management and employee engagement communication platforms for supporting the new remote workforce. For those joining us who are unfamiliar with PROXUS, we support a platform that includes applicant tracking and onboarding, payroll and tax filing, time and labor management, and additional modules in addition to that. We do find that our technology solution works best with organizations who are frustrated with a lack of service, upset over a lack of functionality, or concerned with compliance and the guidance they're receiving. With me today, I have the pleasure of welcoming Mary Ellen Allen from our client McErlane, as well as my colleague Michelle Underhill. And I'll ask the two of you to please go ahead and introduce yourselves. Mary Ellen, if we start with you.
Great. Good morning, Matt, and good morning, everyone. My name is Mary Ellen Allen, as Matt said. I'm a partner with the law firm of McErlane, and I chair our firm's employment law group. I've been practicing law for about 20 years, and I provide employers with advice and counseling regarding all areas of employment, including hiring, discipline, termination, leaves of absence, compensation, and disability accommodation. I also draft employment agreements, severance agreements, as well as employee handbooks. I also represent companies if they get sued in court. I regularly represent employers before federal and state courts, as well as administrative agencies such as the EEOC, in a wide variety of employment law claims, including discrimination, harassment, other employment laws, as well as non-compete agreements. So I'm so happy so many people could join us today. Of course, this is for educational purposes only. This is not intended to establish an attorney-client relationship. Of course, if there's anyone on the line that does need legal advice, I would be happy to talk to you separately at a different time. Thanks, Matt.
Good morning. As Matt said, my name is Michelle Underhill. I'm a senior HR consultant with PROXUS. I've been with PROXUS for approximately 5 years. I have over 20 years of HR experience as a generalist and working in a varied industries such as health, technology, manufacturing, education, etc. I've been involved with startups, nonprofits, for-profits, corporate environments, multi-state environments, and been engaged with HR audits, serving as HR outsourced lead, managing projects, and organizational development, recruitment. I am very happy to be here today, and I hope that we can provide you clarification to all the nuances related to COVID-19.
Very good. Thank you both for that. So in terms of the learning objectives that we want to cover during our time together, I'm going to be going over certainly the timing of reopening, communication to active, furloughed, and separated employees, the compensation and benefits considerations surrounding all of this, as well as the difference between bringing back furloughed and laid off employees. And then finally, we're going to wrap up with ensuring a safe and discrimination-free environment. Throughout, we're going to be providing relevant employment law guidance, as well as some information on the new laws issued during the pandemic. So we do have an hour and a half with all of you today. The webinar from Tuesday did go right up to the end. I promise it is an engaging conversation. So stick with us, and we'll get you some good information here. So before we jump directly into reopening considerations, we thought it important to spend just a few minutes on a recap of important COVID-19 legislation specific to the FFCRA. And Mary Ellen, I'll ask you to kind of just, review for us, please, the main provisions of the FFCRA.
Absolutely, Matt. So the two main leave provisions of the FFCRA are the extended FMLA and the emergency paid sick leave. The extended FMLA is for employees who are parents who have been on their company's payroll for at least 30 days and who cannot work or work remotely because their child's school is closed and daycare is closed or unavailable. It is a paid leave of absence with a cap of, it's a paid leave of absence at 2/3 of the regular rate of pay, and there is a cap included in there as well. The second type of leave is the emergency paid sick leave. This is for all employees, regardless of how long they have been employed. It is a 10 days of paid sick leave. Matt has put up the reasons why you can take that paid sick leave. If it's one of the first 3 reasons, then the employee is entitled to 100% of their regular rate of pay. Of course, there are caps as well. If it's for reasons 4 or 5, which have to do with caring for someone else, then they're entitled to 2/3 of their pay, also with caps involved. And this law, Matt, applies to all employers with less than 500 employees. So it does apply to employers that have less than 50 employees, which those employers are not normally subject to FMLA requirements, but they are in this case, unless they can obtain obtain an exemption, but how that's going to be implemented at this point is unknown. So employers with less than 50 employees whose business would be jeopardized as a result of having to comply with these laws should be documenting that and keeping track if they are going to be seeking an exemption.
So Mary Ellen, 2 questions around this, and then just one comment for the audience, especially as we start to bring people back into the office. When the FFCRA was first passed, I know there is a notice that needs to be posted, hopefully for anybody that had employees working remotely. That was sent out electronically, but particularly as we start to bring people back into the office, just a reminder to make sure that that poster is up next to all of your other federal, state, and local employment law posters. And we do have that out on our COVID-19 resource page if you do need to pull that down and print it off. But in terms of the questions, Mary Ellen, on the previous slide, we showed that the FFCRA expires on December 31st of 2020. So let's assume that all states and businesses are reopened to a large degree as of July 1st. If an employee calls in on July 2nd and says they need leave for one of the reasons here on the screen, are they entitled to it at that point, being that we're now reopened?
Yes, they are, Matt, because this law is valid until the end of this year. So assuming that they qualify for the emergency paid sick leave for one of the reasons that are listed, or assuming they cannot return to work or work remotely because they don't have child care for their children, then they still would be entitled to submit an application for leave under this law.
Okay. And then the second question was, and you kind of touched on it, you said if they qualify for one of the 6 reasons here on the screen, that first reason in response to a federal, state, or local quarantine order related to COVID-19, there was a lot of ambiguity when that first came out. And the question that we got posed a lot was, well, aren't we all kind of under a federal, state, or local quarantine order?
Yes.
And especially as we're very hopeful that there's not going to be a resurgence, but if we do see a resurgence and we do need to tighten back up on restrictions, how do you interpret that?
That's a good question, Matt, because I agree. It was a lot of ambiguity around that. And the Department of Labor has put out guidelines to go along with the FFCRA. And what the guidance says is that if your employer has work for you and you cannot work or telework because of a shelter-in-place order, then you would be entitled to submit for that emergency paid sick leave under the first reason. Keep in mind, this is a federal law and states have all issued their own orders, which vary from state to state, from county to county, from city to city. So it's meant to, the federal law is meant to sort of encompass all of that and take into account that there are differing orders. So, but the bottom line is if the employer has work for the employee, but the employee cannot work because of a stay-at-home order or telework, then they would be subject to that first qualification there for the emergency paid sick leave.
Got it. Perfect. Thank you. And we touched a little bit on the FMLA expansion, but do I have it correct that organizations who previously had to comply with FMLA, and I'm kind of generalizing here a little bit, but anyone over 50 employees, this FMLA expansion doesn't guarantee employees 12 additional weeks. It just gives the additional reason why someone may take that leave?
That's exactly right. So if someone has taken 6 weeks of leave under the FMLA already within the last 12 months, then they would be entitled to an additional 6 weeks, not an additional 12 weeks.
Okay, perfect. And I know one of the questions that Michelle and I pose to our clients and get from our clients often related to FMLA is the the measurement period, right? So somebody gets 12 weeks in a 12-month calendar view, but you can define that differently. So there's the January through December, there's a rolling calendar. Do you have any quick guidance on what may be the better option of how to look at that calendar for FMLA qualification?
Those companies that have already been subject to FMLA, have 50 employees or more, should stick with the procedure that they already have in place. I would say for those employers that have less than 50 employees that are now required to comply with the extended FMLA and don't qualify for an exemption, I would say probably use April 1st, since that's the effective date of the law, as the starting date for the calendar measurement.
Got it. Okay. And Michelle, if we give Mary Ellen a little bit of a break here, I know you help to advise our clients across the country. Besides the leave laws extended through FFCRA, are there other leave laws that could apply to leave of absence due to COVID-19?
Definitely. So there are local laws, there are state laws that have leave provisions in place. So for instance, New Jersey has New Jersey family leave. It also has New Jersey paid sick leave. There is, then in addition to that, you have your private or state disability. So again, New Jersey is New Jersey temporary disability, as well as you might have a private plan called short-term disability. All these leave laws and special provisions come into play. And as you know, states are also developing more generous leave laws as we're developing and navigating through this COVID-19 situation. So we should be looking out for those changes. And I know one change that is coming regarding the FFCRA is that December 2020 date is likely to extend to December 2021. So that's a perfect example of how these laws are changing day by day.
Yeah, and I've heard the analogy used a couple times as we've been having conversations over the last few weeks that we're kind of flying the airplane as we're building it, right? So keeping your finger on the pulse of these leave laws, specific to state and local, because as you said, they are changing. And then on the federal level, we had the stimulus package, second stimulus package that just passed the House. And while the Senate may make significant changes, if it passes at all, certainly there's the pushing out of the dates for the FFCRA, as well as some of the other components that we've seen. So good to keep an eye on all of that.
Mm-hmm.
So with that brief history of the leave and compensation entitlements now available to some employees out of the way, the question that's of course on everyone's mind is, when can I reopen my doors? And between the webinar that we did on Tuesday and today, we've reached a positive milestone where all 50 states are at least partially reopened, indicating that things are heading in the right direction. And then if we take it one step further, then when can I reopen? The question is, what will businesses and my operations need to look like after that fact? And I think it goes without saying to all that are on the line here that our region of Pennsylvania, New Jersey, New York, and Delaware has been one of the hardest hit by COVID-19. I mean, personally, I vividly remember my last day physically in the PROXUS office was Friday, March 13th. So Friday the 13th of all days, and April 1st then marked the statewide stay-at-home order. And although we are considered an essential business here, I've not been back to the office but 1 or 2 days just to pick up some mail. Mary Ellen, as an attorney fielding questions from your clients about these types of issues when we talk about reopening, what are you hearing most related to the timing aspect of all of this?
The question I'm hearing most, Matt, related to the timing is really, so we are, looking towards reopening. What do I do with employees that are uncomfortable about coming back to work? What do I do about employees who refuse to come back to work? I think those are the questions I'm getting most at this point related to the timing and reopening.
Mm-hmm. And we're going to talk a little bit later about that, and
Yes.
as well as employers who choose to stay closed or continue to work from home, even though they may be able to reopen, right? On the other side of that coin, though, I'm starting to see stories of business owners who are defying the work from home orders and opening their doors to customers. This is going to be a phased approach,
Yes.
right? So we're going to see on the next slide, we've got red, yellow, green here in Pennsylvania. We've got the three, the three more local state kind of reopening plans here on the screen. But aside from, just the criminal and, financial penalties associated with maybe reopening before you're allowed to, what sorts of employment law implications or risks does a business owner run by doing that?
In reopening before they're allowed to do it and asking employees to come back despite a state order, from the governor or the Secretary of Health saying that the business must remain closed, I think there's a potential there for a wrongful termination claim. If an employee refuses to come back and therefore they're not being paid, that could amount to constructive discharge. Or if the employee refuses to come back and the employer terminates that employee, and again, we're just talking about people that are reopening against the government's orders, you're asking that employee to break the law, technically, and firing them for not agreeing to break the governor's orders really could amount to a wrongful termination. It could be an exception to the at-will employment, and there are very few exceptions to at-will employment. So that's what I think employers are risking here. I also think there could be an overall effect on morale, which directly affects productivity. Asking employees to come back early when they're supposed to be closed and the employee's not ready to do so really could affect overall morale for the company as well.
Got it. Yep. And I think luckily this is kind of the exception story than the norm, right? I mean, most people are taking the opposite approach and saying, even if we can reopen, we're still going to continue to work remotely for a period of time. But there are those business owners out there, and I get it, I understand it, because in order to survive, you do need revenue coming in, and it's difficult, but appreciate that perspective. Michelle, how about you? What are you hearing from your clients that have had to shut their doors?
Very similar to what Mary Ellen has experienced is, when can I bring employees back? What are my employer obligations? What do we need to do in order to comply? What kind of notifications do we need to provide to our employees? And what recourse can I take if I have employees that are refusing to return to the workplace? So those seem to be the biggest challenges.
Yep. So if we start to look at that, then whether it's a a phased approach or a multi-principled approach, whatever the specific states want to call it, what are you hearing, Michelle, as key indicators of cities, counties, and states being able to reopen?
Well, number one, you must follow your local and state laws with regard to how you can reopen within that particular area. So as we know, Pennsylvania has a phased approach. New Jersey and Delaware are sort of similar. They're, waiting to see a decline in cases over a 14-day period. They want to see enhanced testing and an adequate supply of PPE. They want to be sure that companies can provide safe distancing within their organizations. Primarily, I think, they're really looking at a decline in cases and less activity with new cases. But it is really important to follow the guidance of the local and the state laws.
Yep. And I think a good example here is, the state of Georgia, right? So Georgia was the first state to begin reopening several weeks ago. And, from what I'm seeing now, the rolling 7-day average of new daily cases has fallen for 3 weeks in a row down in Georgia. So that's the type of metric that cities and states are going to be looking towards when deciding how fast and what businesses to allow to reopen. So now we want to go into some specifics related to workplace safety and screening. We'll be starting to touch on those, but before we do, let's spend a few minutes just talking about the two types of employee classifications that have been prevalent throughout the crisis here and throughout our conversations. Furloughed versus laid off employees. So sadly, we know that many employers have had to make the difficult decision to either furlough or lay off employees as their operations and revenues were negatively impacted by the crisis. And this was one of the principal reasons for the FFCRA legislation that we discussed earlier, certainly the CARES Act with the PPP loan, the additional $600 with unemployment. So it's all designed to put money back into the pockets of those individuals who were affected through this. Mary Ellen, from a legal perspective, what are the differences here between a furlough and a layoff?
Sure. Well, a furlough is a temporary leave of absence from employment in the form of either voluntary time off or mandatory time off. The time off could be in full day or full week increments, but the absence is generally short, it's temporary, and the employee maintains his or her employment. So they remain an employee of the company. On the other hand, a layoff is for an indefinite period of time and more than likely permanent in nature. And that employee is looking for new employment and they are no longer considered an employee of the company.
So with a furloughed employee, safe to say that still subject to employer policies. So any handbooks or technology policies or non-disclosures or anything that were signed are still in effect. Whereas with a layoff, that employer-employee relationship has been severed. So those are no longer valid.
That's exactly right. That's exactly right. Furloughed employees, they are still employees of the company. If they've signed a restrictive covenant, that still applies. Any handbook policies that apply during a leave of absence are still in effect. Whereas, as you said, a layoff, it's a termination. They're severing the employer-employee relationship.
Okay, and Michelle, if we turn to you real quick here, as you were working with your clients, and now that we know the difference between furlough and layoff, because a lot of times, those were kind of used interchangeably, in general, did you see more businesses laying employees off or furloughing them?
I've seen both, but I have seen layoff as a more common action. So those employers that couldn't anticipate whether somebody would be able to return to work, or those employers who needed to reduce their workforce, eliminate, departments, and or shut doors. But the employers that furloughed were those that wanted to have employees work intermittently, maybe a week on, a week off, or reduce their schedule, or they really wanted to maintain their employment status and their benefits because they were anticipating being able to call them back.
Okay. Yep. And that'll come into play here when we start talking about some of the next slides. In terms of communication, obviously the three of us know that in the world of employment law, employee relations, and just employment in general, communication is critical. And we've seen a lot of information coming out that the level of importance is compounded exponentially in times like these when it comes to communication. If we start with you, Mary Ellen, are there things that employers are required to communicate to their employees related to COVID-19?
Yes, I have seen changes in compensation. Some companies are reducing salary due to a loss of revenue. So any changes in compensation or changes in benefits have to be communicated to employees. And changes in compensation, you're required to give at least one full pay period's notice, but ideally, I think 30 days notice at least is what employers should be giving to employees. Also, safety procedures. How is the company complying with orders from the Secretary of Health or the CDC guidelines or OSHA regulations to ensure that their company will be safe for employees to return to? So those things really are required for employers to communicate to their employees.
How about anything that's maybe not necessarily required, but best practice or that you would recommend?
I think the frequency of communication would be a best practice, making sure that the employees know that it will be a safe workplace to return to. I think, communicating that frequently, letting them know about updates that employers are doing to their building, to their workspaces, in order to keep employees safe. It really is best practices. I think the more communication in these types of situations, the better.
Yep. Michelle, anything that you wanted to add there in terms of frequency, form of communication specific to business operations?
Yeah, I think it depends on the employer, but I have seen weekly communications, just COVID related, what's going on, what's the status, what are our plans, what changes we need to continue to make. I do think it's a best practice. It's just positive employee relations. It's showing that you care for your employees, you value them, and you're, giving them the courtesy of letting them know what's going on and what your thoughts are. As far as I think it's critical to keep them informed of what your plans are as far as reopening, what your cleaning practices will be that are different than what they were before. So it's important to reassure employees that they're going to be returning to a safe work environment and you're taking extra precautions. And when you are ready to reopen, it's critical to let the employees know your intentions, what you're targeting as your return to work date, and any benefits or compensation that might be offered that's different than before. Also, in a very nice way, what the consequences would be should you not return to work because we have work. So, maybe making employees aware that their continuation of unemployment could be jeopardized should they decide not to return to work, and that their benefits would terminate effective immediately.
And that gets into, kind of our next portion here of recall notices. So one of the maybe unintended consequences, of the CARES Act, which expanded unemployment compensation eligibility and added that extra $600 per week to claimant payments that I mentioned earlier. Mm-hmm. The unintended consequence here is that some individuals are now making more on unemployment than they did when they were at full-time status in their former jobs. Because of this, some of our employers are finding it difficult to bring people back to work. So Michelle, as you're working with your clients on reopening their businesses and bringing employees back into the workplace, how and what are you, advising that they communicate with their furloughed employees?
Well, some of what I just said, what kind of benefits or compensation practices are going to occur that could be different. Employers are looking to, create incentives for employees to come back to work. So some employers are able to enhance compensation, provide hazard pay, for instance, return to work bonuses, maybe provide additional rewards should revenues achieve, certain targets. Some employers really can't do anything, so they're more challenged because they have to find ways to get their employees to come back. And I think that goes back to, okay, should you not be able to come back, you're probably going to lose your unemployment and your benefits will terminate. So hopefully that is, a deterrent for individuals to make a decision not to return to the office or the workplace.
And along those lines, Mary Ellen, with unemployment comp and just other types of leave and things in general, if an employee refuses to come back, right? So we're allowed to reopen, we've issued a recall notice, and the employee is still refusing to come back. In my experience, unemployment's kind of always been a flip of a coin. Does that automatically bar them from continuing to collect unemployment, or are there certain circumstances under which an employee might have a case here in refusing to come back?
Yes, it really depends. So if an employee doesn't want to come back to work because, as Michelle was just talking about, they're making more through unemployment compensation than they would if they came back to work, that's not a valid reason not to come back to work. And unemployment compensation is for people that are ready, willing, and able to work. So if there is work available to that individual, then they're not entitled to unemployment compensation. So that in and of itself is not a valid reason not to come back to work. And there can be consequences for that, losing unemployment, losing your job. In certain circumstances, it may be a valid reason not to come back. Let's take, for example, someone who has an underlying medical condition who puts them at high risk for contracting COVID. Perhaps their doctor is recommending that this person not be in a public workplace, regardless of how many safety precautions have been put into place. So in that case, they may be entitled to a reasonable accommodation for their underlying medical condition, which could include continuing to telework or perhaps some sort of finite leave of absence. Also, if an employee refuses to work because they believe they are in imminent danger, that they have a reasonable belief that there's a threat of serious physical harm, then they can bring that to their employer's attention and refuse to come to work until that's corrected. If the employer takes an adverse action against that employee, they could be violating OSHA, the OSHA Act, Occupational Safe and Health Act. So if an employee brings a valid concern, not just a general, I'm concerned about coming back, but a valid, legitimate, I feel there's an imminent threat of serious harm to me, to the employer, that could be a valid reason for not coming back to work as well. So really, there's a few issues that could be flagged. Another one is, what if they don't have daycare and they can't come back to work? Maybe they're entitled to that extended FMLA leave that we talked about earlier. So it's really up to the employer to get to the root of the issue. If an employee is refusing to come back to work, there has to be a number of follow-up questions to understand the reasoning why, to see if there's obligations, legal obligations that are triggered that the employer has to comply with, or if it's just the employee, I'd rather stay out on unemployment and stay home, which obviously would not be a valid reason.
So for those sorts of conversations, right, there's quite a bit of back and forth there, right? So if I'm bringing a valid reason for why I don't want to come back to work, you're obviously going to have a conversation, and best practice is, of course, to document that, keep it in a file. But in terms of just the general employee response to recall notices, and we're not going to go into the CARES Act or the PPP loan forgiveness, and in this webinar, we'll certainly do that on upcoming webinars. but just for maintaining those records, right? So if it's a simple, yep, I plan on coming back when I'm recalled on the 1st, or I'm going to need an extra 5 days, best to just kind of keep that documented and in the employee file.
Yes, certainly best to keep that documented and document all conversations, interactions with that employee. I think it would probably be best to designate one employee to be the one to document and have those interactions with the employee, whether it be the head of HR, or if there is no HR manager there, then the employee that handles the HR function. So this way, there's one person at the company that is filtering that information and taking that information and appropriately interacting with employees and absolutely documenting the interactions.
Got it.
And
okay.
if I may add, as far as filing that information, just do not file it in the regular personnel file. Anything regarding medical or health notes from doctors should not go into the regular personnel file.
Yep, no, great point there, Michelle.
Absolutely,
and then
great point.
Last question, Mary Ellen, and then we'll move off of this slide, but we talked about the layoff and furloughed employees. For those employees who were actually laid off, so we severed the employer-employee relationship, even if it was for 2 weeks, 3 weeks, 4 weeks, right? Because it's hopefully not going to go much longer than that. But if we're assuming it's 2 months or less, does it make sense to, when we recall those employees, to put them back through the entire onboarding process? So new I-9, new W-4, re-signing policies.
Yeah, yes, employees that are returning to work who remained on payroll would generally not need to complete the new paperwork. So the furloughed employee who, as we talked about earlier, remains an employee of the company, there's no need to fill out all of those onboarding documents. The terminated employee, when there was an actual layoff and the employer-employee relationship was severed, it is important to fill out those onboarding documents once again, just like you said, the I-9, the W-4. Another example would be if there are employees who signed restrictive covenants, including confidentiality agreements. If you've terminated that employer-employee relationship, it's important to get those types of important documents re-signed so that they are valid moving forward.
Yeah,
benefits as well, benefit enrollment. If it's a furloughed employee and they were able to stay on the benefits, no need to fill out benefits paperwork again. But if the benefits were terminated because the relationship was terminated, then of course there'll have to be enrollment as well.
Very good, and that's a great segue into our next section here, which is on compensation and benefits. And this is an area that was really thrown a curveball with COVID-19 and stay-at-home orders, FFCRA requirements. As a payroll and HCM technology provider, our team here fielded many questions related to benefit eligibility, salary versus hourly, exempt, non-exempt pay considerations, certainly leave of absence management, as I'm sure was also the case for you in your practice, Mary Ellen. Unfortunately, one of the consequences of the situation we all find ourselves in is going to be a rise in lawsuits brought by employees against their employers, many of which are going to end up being related to compensation and benefits here. And in conversations with my broker partners over the last weeks, many of the familiar carriers have increased flexibility around payments of premiums, eligibility requirements, and other what we would call normal plan design aspects. Employers were quick to question what that meant for employees who were terminated or furloughed. And Michelle, what considerations do employers need to be aware of as they start to bring employees back to work related to benefits?
Well, though they would need, for those that were laid off and brought back, they would need to check the plan documents and the carrier agreements to see whether or not benefits can be resumed immediately without waiting their traditional introductory period. So they can't just assume that they can reinstate benefits upon return immediately. They do have to check those agreements to make sure that that's okay. As far as payment of collection of premiums, they can just resume the payroll deductions for whether they, prior to them being furloughed, they would have had to determine, how they were going to handle premium payments while they were furloughed. So there shouldn't be any, changes with that. If they had to pay back those premiums, they can do additional payroll deductions to catch up. But hopefully those plans were communicated in advance to the employees so that there's no surprises.
And for those, for those employees who weren't able to continue their coverage under the normal plans and maybe had to go on COBRA, I know recently the Department of Labor, IRS, in conjunction with the DOL, released guidance around COBRA eligibility and the election period for employees. So talk to us about some of the changes that came about from those, that new guidance.
Well, generally speaking, COBRA has loosened up their requirements. So for instance, traditionally you had 60 days from your termination date to make a decision whether you wanted to elect COBRA, continuation of health benefits. Now that time has been extended. So it's now, I think, 60 days beyond the lifting of the national emergency. Also, you had 45 days, once you made the decision to elect COBRA, you had 45 days to make your first premium payment. That has also been extended. Then thereafter, you have 30-day grace period to make your monthly premium payments, and that has been extended as well. I think we're going to be seeing more revisions to COBRA, because I know there are some things that are pending. But again, it's another area that we need to keep in touch with our brokers about and stay on top of, to be aware of what those changes are so we can guide our employees appropriately.
Yep. And a question we got from our audience on Tuesday related to election periods is, who pays for the premiums during the time that employee has to decide if they want to continue coverage, and then also during that grace period that they have to cut the check to pay for that coverage?
So the point with COBRA and having that 60-day period to make your decision, if you decide on the 56th day, right now that's extended, but if you decide on the 56th day that you want to continue your health benefits through COBRA, then your benefits would be retroactive, so they would go back to the first day of your unemployment. And then you have 45 days, which has now been extended, to make the premium payments for those 2 months. Okay, so premiums do not have to be paid for until after that payment period has expired. So, or not expired, within that payment period. In some cases, employers have decided to pick up the premium payments for a period of 60 days to assist the employees through this time. But then that would be considered the, election period, and then the employees would be responsible for then paying the monthly premiums within that monthly grace period.
Got it. Okay. So then continuing on benefits here, Mary Ellen, I'm very interested in your take on leave of absence accommodations and other types of benefits that we have here on the screen. So FMLA, disability, for employees who are returning to work or being asked to return. We've talked a lot about the expanded FMLA under the FFCRA and its interplay with the normal FMLA, but expand upon that for us real quick. Can an employee claim to need the expanded FMLA 4 weeks from now once a business is reopened?
Yes, because that law, the FFCRA, that expanded FMLA, extends at this point to the end of the year, and as Michelle pointed out, it may extend into next year as well. They can claim that 4 months from now. And I think, for the extended or the expanded FMLA, which again is for childcare purposes, I think that's going to be entirely dependent on what states do with school openings in September, or whether or not, once companies reopen over the summer, is there available daycare? Are there available camps? Because that's just completely in flux at this time. But employers need to keep in mind that those laws will remain in effect even after they reopen their doors. So yes, an employee can claim to need that expanded FMLA several months from now.
Okay. And I know, as we talk about getting back to work and, sanitizing and social distancing, one of the big things is wearing a mask, right? So how about the ADA, the Americans with Disabilities Act, and its interplay with accommodations? What obligations do employers have to, accommodate an employee who may have anxiety by wearing a mask, or who may be unable to sufficiently breathe because of an underlying health condition? These are going to end up being real conversations that employers are going to need to have. So how do they go about doing that?
So employers, they can require a face mask, and probably should do so, and under certain orders from different states may be required to do so, to wear that personal protective equipment in the workplace. So if you have an employee that is unable to wear a mask at work, or refuses to wear a mask at work, it depends on the reasoning why they won't wear a mask. If it's just, it's uncomfortable, it's itchy, well, that's not a valid reason to not wear the mask. If it's, as you pointed out, anxiety by wearing a mask at work, well, what is the root of that anxiety? Is there a medical professional behind this saying that, yes, they have such anxiety that they are not able to wear a mask at work? There would be a need for a doctor's certification to back that up, or, an underlying health condition that would not allow the employee to wear a mask while at work. So the employer, now we've triggered the Americans with Disabilities Act, and the employer has an obligation to enter into that interactive process to see if there can be an accommodation made for an employee such as that. And the employer can send the employee home while they figure out what the reasonable accommodation is. And they'll have to, get a little bit creative. I mean, perhaps providing the employee with an unpaid leave of absence until face masks or coverings are no longer required at work. Or if telecommuting, working remotely is going well and the employee can do their job from home, perhaps allowing that employee to continue to work remotely, again, for a finite period of time while masks are required. Or perhaps the employee's doctor has a suggestion for an alternative face mask or covering that is allowed by the employee's medical condition. So again, it really depends on the reasoning as to why the employee cannot wear a mask. If it's just personal preference, then the employer can say, I'm sorry, but this is a requirement. If there's an underlying medical reason, then the employer has to engage in the interactive process and try to reach some sort of reasonable accommodation.
Yep. So, it seems as though there's going to be a little bit of work here, right? You can't just have that blanket statement of everybody has to wear a mask regardless. It could result in, a lengthy discussion and a little bit of back and forth, and maybe a few days of work on the employer and employees, side to really make this work.
I agree, and I think employers have to be a little bit patient here. I think in general, employers and companies are frustrated because this is a difficult time for everyone. Revenue is down, and so they're anxious to get back to work. And then there's a whole host of other issues that go along with reopening. So, employers are going to have to exercise some patience and due diligence here and make sure that they're dotting their I's and crossing their T's, because on top of everything that they've experienced in terms of the results of this pandemic, you don't want to add employment claims onto the pile.
Yep. And I'm going to stay parked here for 1 minute longer. When we're going to talk about HIPAA coming up here, specific to screenings and employees that we know have either had or been in contact with somebody that's had COVID-19. But real quick, Mary Ellen, with the interactive process, who should be engaging in that at the employer, right? Because the question that we have is, is requiring a doctor's note a violation of HIPAA, or could it be a violation of HIPAA?
So it should be, the HR manager, the person that normally deals with employees' medical issues. That should be the person that's dealing with any underlying medical conditions that are affecting an employee's ability to work due to COVID. So I think it should be that same person, and as Michelle pointed out earlier, medical information for an employee is still confidential. It must remain confidential. It should not be kept in a personnel file. It should be kept in a separate area to which only certain personnel have access, whether it be the HR manager or director or whoever handles the HR function. But it should be a designated person, Matt, who is handling that interaction. And there are times where the supervisor of that employee needs to be brought into the loop as well. And as long as the supervisor or manager is trained appropriately and they understand that this medical information is to remain confidential and that they are given access to it only because of their position of authority over this employee, then I think that's fine as well. But it shouldn't be just carte blanche access for higher ups or anyone feels that they want to know.
Sure. Okay, great. So then with that, let's move into actual compensation. And, we've touched a little bit about changes in compensation, but certainly the pace at which employers have had to make decisions and, the almost daily changes of information and interpretation around the regulations have made decisions around compensation difficult. Can I reduce pay, rate, or salary? Can I furlough a salaried exempt employee and still maintain their exempt status? All the types of questions that we were getting. From a purely legal perspective, if businesses are starting to reopen but can't afford to keep pay rates at pre-COVID-19 levels, can they reduce those rates? And I think we've already answered that. The answer is yes. It's just make sure you give advance notice as much as possible.
Correct. It has to be at least one full pay period of advance notice. You can't retroactively give notice to employees that their pay has been cut. You can't wait until the Friday of payroll and say, listen, for the last 2 weeks, we had to cut your pay, so your pay is going to be less today. It has to be on a going forward basis. So at least one full pay period, ideally at least 30 days. And I think we're at a point where, companies can speculate as to whether they're going to need to cut pay going forward. Back in March, it was a little bit more difficult to tell, and it was sort of last-minute decisions being made. But at this point, I think companies are in a different position, and perhaps they can chart out their revenue for the upcoming months to see if a pay cut is necessary, but advance notice is required.
Yep. And real quickly here, in terms of proper FLSA classification. So, hourly employees are easy, right? It's make sure you pay them your hourly rate, and if they go over 40 in a work week, make sure you're paying them the overtime. But for exempt employees, talk to us real quick about what it means to be exempt, the levels of salary that need to be maintained, and then, one step further than that, if an employer, on the line with us today or 2 weeks from now, looks back and says, oh man, I did reduce salaries, I didn't give my employees 1 pay period's notice or 30 days notice. Are there any good faith efforts that employers can make to protect themselves, knowing that litigation is going to increase?
So, to start with your first question, so all employers should start with the proposition that everyone's non-exempt and everyone's entitled to overtime unless they meet one of the exceptions. To qualify for an exemption, employees, they must generally meet certain tests regarding their job duties, and there's different classifications for that: administrative, professional, executive, outside sales. They must be paid on a salary basis, and they must be paid not less than $684 per week. So it's approximately $35,000 per year. So if we're talking about pay cuts for exempt employees, that can be done on a going forward basis. And if you want to make sure that employee remains exempt, then the pay cut should not take that employee below that $35,000 threshold, that's $684 per week. looking back, if employers realize that, they weren't doing things properly. For example, exempt employees in general, they should not experience a variation in their weekly pay, even though their hours may vary. So if, an employer has been cutting an exempt employee's salary or reducing it on a weekly basis, and it is varying from week to week, that's where you could jeopardize the exemption classification there. So if it's a sustained salary cut on a going forward basis, for an indefinite period of time, not just for, 4 to 6 weeks, then that's acceptable. Again, making sure you stay above that $684 per week threshold. If employers have made mistakes over the last couple months, I would say, make that good faith effort, look back and see if you've jeopardized the exemption for an employee. And if you have, perhaps take a look at, did that employee work overtime during that time period? With all the cuts in hours going on, it's probably more than likely that they did not work overtime during that period where their pay was being cut or it varied from week to week. So going forward, make sure that they are getting their standard salary on the weekly basis and that it's not varying from week to week. And that's really the good faith effort that you can make going forward.
Got it. Perfect. So moving from comp and benefits now into ensuring a safe, and I think the interesting part about the next couple slides is that discrimination-free environment. So we've all seen a lot, whether it's an article or a webinar on that safe component, but the discrimination-free portion is going to become increasingly important as people are brought back to work. It's no secret that with many things, opinions on the severity of COVID-19, when to reopen, do I wear a mask, do I not wear a mask, all of that varies. And that said, there are certain requirements that were already in place and others that are being in place or put in place by the federal, state, and local governments dictating safety requirements. So before we get into those new requirements, Mary Ellen, talk to us about the everyday responsibilities employers have to maintain a safe workplace. What agencies oversee those responsibilities and what agencies put out that type of guidance?
So really the agencies that oversee those types of responsibilities are OSHA, as well as the Department of Health, to make sure that there is a safe and clean work environment, in particularly OSHA, to make sure that there is a safe workplace for all employees.
Yep, and Michelle, we talked earlier about the phased approaches to reopening red, yellow, green here in PA. As we get into the yellow and green phases, what are the rules and guidance that's being imposed on employers who choose to reopen and recall some of their staff?
In the yellow phase, they really would like employers to continue teleworking if that's available and feasible. So they should not be bringing employees back to the workplace if they can continue that form of work. The stay-at-home has been lifted. It is critical that the employers enhance their cleaning and sanitizing, that they communicate what employees' responsibilities are as far as keeping, cleaning before and after they touch shared equipment, and just taking extra precautions to make sure the environment is safe and protecting the confidentiality of employees who may have had COVID-19, may have been exposed. I think that's where there's a risk of discrimination and how those individuals will be treated.
Does it make sense to, as we have the first bullet point there on the slide, does it make sense to assign a specific health and safety officer or health and safety team?
I would recommend that. It depends on the size of the organization. In your larger organizations, I would say that that's a good idea because it kind of brings things together. It provides some standardization in an organization, and it's helpful to for communication purposes, developing plans, and for monitoring the situation. In smaller employers, it might not be feasible, but there are certain industries where it is mandated. It is not mandated in all industries, but in certain states and in certain industries, there is a mandate for safety office, such as construction. So I think it's important for employers to know what those mandates are and how they impact their organization.
Got it. And in addition to providing the guidance to employees and the specific business plan here for reopening safely, many employers or many employees are going back to office buildings that are shared, right? Us included.
Mm-hmm.
So we've got property managers here, and there's 3 other businesses that share this space with us. So I think there's a consideration that needs to be given to communicate the information that's put out by the property managers. Certainly, I know we were provided with our plan by the property management team here, what their plan is for the common areas for increasing cleaning in each of the suites. But then, one step further, depending on how large or small the building is, having that safety team or that safety officer also coordinate with the other tenants, right? Because it's one thing for a particular tenant to all wear masks in common areas, but if other tenants aren't following the same type of guidance, I think it's got to be a coordinated effort, and having that safety officer to kind of be that liaison between all of the tenants is an interesting consideration with all this.
Mm-hmm, definitely. I think, if you're sharing a building with other tenants, there needs to be some consistency and uniform practices. And hopefully the property management group can influence that as well and mandate some requirements so that everybody's following it.
Yep. And then Mary Ellen, with this one, I'm definitely going to turn to you. I mean, as an HR practitioner, the thought of taking an employee's temperature or doing any sort of screening as they're walking into the building seems so foreign to me. And informing employees of any medical diagnosis, yet this is something that's now, in some circumstances, the responsibility of employers. And I have a lot of questions for you around that. Help me understand the implications of taking somebody's temperature again as they walk in the door and seeing a reading of 101.5 or 101.6 or anything less than that. What laws pre-COVID were in existence, and does this mean that they've essentially been suspended because now we have to take the temperature of our employees as they walk in the door?
Okay, it's interesting times for sure. So pre-COVID, taking an employee's temperature is considered a medical exam. So employers are not permitted normally to just conduct a medical exam or force their employees to submit to a medical examination, except in certain circumstances, perhaps a workers' compensation issue, or it could be a conditional offer of employment and the medical examination is part of the pre-employment requirements because it's related to that employee's new position. But because COVID-19 is a pandemic and it is considered a direct threat, some of those requirements and restrictions are relaxed, and employers are permitted to take the temperature of their employees, even though it is a medical exam. But as we've been talking about throughout the course of the webinar, all medical information of employees is confidential. And must remain confidential. So taking an employee's temperature should not be done in a public space. It should be done in private, the results of which should be kept confidential. If an employee does have to be sent home because they have a temperature over 100.4 degrees, again, that should be kept confidential. So while the restrictions are relaxed because of the pandemic, the confidentiality restrictions are still very much in place.
Mm-hmm. And along those lines, I'm curious to know who you believe at an organization should have the responsibility for doing these screenings, right? A lot of our clients on the phone might not have a dedicated HR representative. So, does it make sense for the front office receptionist to be the person that's responsible for this, or does it have to be the CEO, CFO? Talk to us a little bit about that.
I think companies, large or small, should designate someone. I mean, if they are larger and they have an HR manager or an HR department, it should be someone in there. If they do not have that, who handles the HR function in the company? It should probably be that person then to handle the screenings, assuming that person feels comfortable, or designate, a health and safety officer temporarily during this time frame for the reopening. So that person can conduct the screenings. I probably wouldn't vary the person that's doing it. If it can be consistent, that would be best for all the confidentiality reasons that we talked about. I probably wouldn't make it the receptionist. I think it should be someone who handles the HR function for a company.
I also wouldn't advise for an executive level position or the organization's leader to engage in this.
I agree with Michelle. It should be a designated health and safety officer or a designated HR representative or manager who handles this function.
Got it. Great. Thank you. And we started the section by saying that we were going to talk about avoiding discrimination and protecting rights. And you talked a lot about the confidentiality aspect of this, right? We know that employers can't specifically come out and say, hey, Sally from accounting's tested positive for COVID-19, but we also know that employees talk, information travels fast, and if 3 people are walking in the parking lot, together in the morning, and 2 make it into the building, and 1 miraculously, doesn't make his or her way to the desk because they have 101 fever, somebody's going to look up and notice that, that person didn't make it into the building that day. What should employers do to help mitigate the potential, for discrimination against these individuals? What do you what responsibilities do they have, and what proactive steps can they take to mitigate that? So either one of you, if you want to, go ahead.
Sure. I'll start. Is that all right, Michelle?
Absolutely.
So, to help mitigate, I think this is where training comes into play. I mean, just like companies train all of their employees, all of their managers about harassment or discrimination in the workplace when it comes to a protected class. Now, someone that has COVID isn't necessarily in a protected class, but they could be if they have an underlying medical condition. But to avoid, that sort of chatter, that gossip, anything that could lead to harassment in the workplace, which of course no company will tolerate, I think training is important. Letting your managers know that their employees should not be talking about someone else's confidential medical information, making sure managers understand that they should not be talking about an employee's confidential medical information. I think, just an email and training in this area will go a long way to mitigate that.
Yeah. Okay. And then, we've also got up there protecting rights. So on the employee side, if we've got an individual employee or a group of employees who aren't happy with the safety precautions that have been put in place, and they're having a conversation in the lunchroom or on social media, are they protected to have that type of conversation?
They are protected to have that type of conversation under the National Labor Relations Act. Employees, whether they're in a union or not in a union, it doesn't matter, do have the right to talk about their working conditions, and that includes the safety of the environment in which they work. So they do have a right to discuss that. My suggestion would be to have a complaint system in place, just like companies do with a complaint system for harassment or discrimination. Have a complaint system in place. Have a designated person that employees can go to say, these are my concerns about the safety of the workplace, and what are you doing to address that, or what have you done to address that? Because I think communication here goes a long way the employee's concerns may be unfounded. It may be something that the employer has already addressed, or maybe something that the employer didn't think of and then does want to address. So to alleviate just the chatter and complaints, I would have a designated person and a complaint system in place.
Great. Yep, makes a lot of sense. Perfect. So appreciate you guys, spending some time on all of that. And now what we're going to move into for the remainder of the conversation is our question section. So if we start just jumping right in, first question that we have is, can a furloughed employee apply for Pennsylvania unemployment? And I'll broaden it out from there. Just, can a furloughed employee apply for unemployment? So Michelle, if you want to take that one.
Yeah, absolutely. Whenever work or hours have been reduced, every state's a little different, but they can certainly apply for unemployment, and then it would be up to unemployment to make a determination whether they'd be eligible.
Perfect. Next question we had, same thing, Michelle, we'll stay with you for this one. What recommendations do you have for yellow versus green openings? If an employer or employee can still telecommute, although it might not be ideal, does it make sense to do that during the yellow phase, or is it better to hold off?
Yeah, as we said before, I mean, during this yellow phase, the return to work provisions are still restricted, and if you can continue to telework, it is strongly advised to do so.
Right. And then, to the actual safety and cleanliness of an office, what do we as an employer need to be aware of or plan for related to sharing common areas?
Definitely plan in advance. I think you need to look at your workplace, how the workspaces are set up. Do you have cubes, one right next to another within 6 feet apart? Do you need to modify that workplace so that there is distancing and there is protection between people? I think modifying the use of common spaces such as kitchens, restrooms. If the restrooms are too small to allow for 2 people or 3 people at a time because they can't be 6 feet apart, then maybe it's 1 person at a time. Conference rooms, when at all possible, continue to use teleconferencing instead of being gathered in one room together. If you are in one room together, again, you want to follow the 6 feet apart. You do not want to position people directly across from one another. Side by side is better. The other thing that I would state is you should have signs throughout your facility reminding employees of the safety precautions that they need to take. Employees should be responsible for cleaning high-touch surfaces or surfaces that are touched by other people before and after their use. And I think primarily that's about it. I could have missed something, but.
Yep, good advice. Mary Ellen, if we turn to you for this one, and we touched on it, kind of throughout the discussion earlier, what are the HIPAA implications for screenings of employees and visitors?
Again, I mean, all medical information needs to be kept confidential. So as we talked about a little bit earlier, screenings should be done in private. They should not be done in a public space. They should not be done in front of other people. And the results of the screening should also be kept confidential. If someone needs to be sent home or turned away, it should be done privately. It should be done discreetly.
Got it. And this is one that comes up a lot, actually. So, how do employees who have compromised immune systems themselves, or who might live with others who have compromised systems, impact ADA and disability claims? And then second component of that is, should we be requiring from employees anything in addition to FMLA paperwork?
So with regard to the first question, if the employee is the one who has a compromised immune system, meaning that they have some sort of underlying medical condition, then they can be considered disabled under the Americans with Disabilities Act, and they may be entitled to a reasonable accommodation. So if it's the employee with a compromised immune system, and the employee brings it up, saying that they have an issue with returning to work, then the employer has to engage in that interactive process to see if a reasonable accommodation can be made. If that employee lives with someone who has a compromised system, that's not something that the employer necessarily has to accommodate. It's not required under the Americans with Disabilities Act that you engage in the interactive process because of someone that the employee lives with. However, I mean, I think employers are recognizing that they need to be a little flexible during this time frame. So maybe even though there's no legal requirement, it may be best practices. If that employee can continue to telework, can work remotely effectively, and can complete all aspects of their job doing so, maybe the employer could offer that accommodation for a finite period of time. With regard to should we be requiring from employees anything in addition to FMLA paperwork? Well, it depends. So for FMLA purposes, right, it's the FMLA paperwork that you need. If it's someone with an underlying medical condition that needs an accommodation, then there are forms that the employee's doctor should fill out related to what they can and cannot do as a result of their disability. So those forms would come into play if there's an employee that, if we're talking about someone who can't come back to work or cannot work due to their health condition.
Got it. All right. Next question we have was, what can you do if you have information about an exposure to COVID-19 that makes you uncomfortable going back into the office, and you want to continue to telecommute? Michelle, maybe you want to take this one?
Sure. So when you're talking about exposure to COVID-19, are we talking about knowing that employees may have, coworkers may have been exposed, or that they're engaging in behavior outside of the office that increased their exposure?
So that's actually, it's a good question. The next slide that I have here is actually if you do know of a coworker who's engaging in activity outside of work that may put them at an increased risk for contracting COVID-19, what are your options? But similar question to this one, and that's exactly how I would look at it, Michelle, is if I know of somebody at my organization who either had COVID-19, has COVID-19, or is at an increased risk of getting COVID-19, what are my options?
Well, again, I think if you there isn't a medical reason that prevents you from being in the workplace due to compromised immune system or a medical condition, I think that you have to comply with the request to report to the workplace and discuss it with your manager or HR. How can they assure you the steps that they're taking in order to provide a safe workplace? PPE, the mask, gloves if you would like, and all the cleaning practices and the safe distancing. But I think it's important for the employee to engage in a conversation with human resources or manager if that's more appropriate, and explain what their concerns are. We don't have a lot of control over what people do outside of work, and I'm not sure how involved we can really get in that.
Yep. No, and I mean, go ahead, Mariel.
No, I was just going to say, I completely agree. I mean, I think communication is key here. So if somebody has concerns, they shouldn't hesitate to voice that to the proper person within their organization, because I think employers recognize that communication from the employer to the employees is key. So they're going to want to know their employees' concerns.
Yep, very good. So I'm going to skip over this one because we kind of addressed both of these questions simultaneously. The next one, and I'm not going to say who asked it or anything like that, but the question was raised: is being part of an at-risk age group ADA qualifying?
So my opinion on that is no. In order to qualify as being disabled under the Americans with Disabilities Act, the person has to have a condition that it affects an essential life function. And just being part of an age demographic does not affect an essential life function. So my opinion is no, it would not.
All right. And we're coming up on our last couple slides here, guys, so please hang in there with us. We should wrap up right on time here. The next question we have is, after we get to the green phase, can an employee with support from a doctor's note insist that they telework indefinitely? What do you think about that, McErlane?
Indefinitely would be, I think there's going to be a lot of it depends. Okay. So once we get to the green phase, is the person at risk? So if they have a doctor's note that says that they can never come back to the employer's place of work, it's really going to depend. Can they do the essential functions of their position? Are they compromising the employer's daily functions by not being in the office? So, again, that's going to come down to, is this an ADA disability? Is this a reasonable accommodation? Can the employee actually do all of their work by telecommuting? So I don't think there's a hard and fast answer to that. I think it's going to be dependent on a lot of different factors, and the interactive process will be important there.
And I think another point to be aware of, while we might end up achieving this green phase, I think employers need to be prepared that we may have to go back to a restrictive work setting, or resorting back to teleworking, because this COVID-19 is anticipated to return in the fall and the winter, and although we're still learning every day something new about it, we don't know all these answers. It is a possibility.
And I think a lot of the guidance that we just gave also applies to this question is, how should we handle an employee who's out on FMLA but is unable to return to work? So, FMLA is FMLA is FMLA, right? So whether it's the quote unquote old FMLA or the expanded FMLA, McErlane, what do you think about somebody who exhausts their FMLA entitlement but then, can't come back to work for whatever reason?
So it will depend on the reason. That will, trigger what the employer's response must be. So let's just say it's regular FMLA and the person had a serious health condition, or they were caring for someone with a serious health condition. If they can't return to work because of their own serious health condition, they may be considered disabled under the Americans with Disabilities Act, and the employer will have to engage in the interactive process to see if an extended leave of absence for a finite period of time would be reasonable and something the employer could do, and something that would help the employee so that they can return to work then. If the employee is out because they're caring for someone with a serious health condition, or they were out on the new expanded FMLA because their child did not have any daycare, and they're still unable to return to work, off the top of my head, I can't think of any other legal obligations the employer would have to continue to hold that position. But again, I think employers are understanding that they need to be somewhat flexible here, and perhaps a few more weeks, if it's not an undue hardship on the employer, may be reasonable. But in terms of legal obligations, I think for someone that's caring for someone else, or someone who's out because of a daycare issue, the legal obligations for the employer end there.
Got it. And then the last question that we have here, we already answered the top section previously, so I'll move on to just the bottom one, which I think is a good softball question. We're an essential business. We can. When can we call our team members back to work? Michelle, you want to take that one real quick?
Sure. If you're an essential business, you can call your employees back to work. If you have employees that are not considered essential to your operation and they can continue to telework, then it's safe and okay to let them continue to telework. But if you absolutely need them in the office in order to resume business operations and increase business operations, then you can open and have employees return to work.
Very good. So with that, I want to take the time to thank both of you certainly for your thoughts, expertise here in this area and perspective on the topic. Also want to thank our audience for joining us. Please feel free to reach out to any of the three of us here that we have on the screen with our contact information. Happy to help with any additional questions that you may have. Other than that, please stay tuned for additional webinars coming up related to the PPP loan forgiveness. As we have gotten and seen some additional information on that whole process. But otherwise, thanks again, stay well, and have a wonderful Memorial Day weekend.